Welcome back to King County Law Library's series on how to with court procedures in the King County Superior Court. Our returning guest speaker today is Rosemarie Lemoyne, and she's here to talk with us about informal family law trials.
Thank you, Rick. Thank
Hi,
you,
Rosemarie.
for all that you do.
You're
Everything we're
welcome.
talking about today, you can find at the library. Resources there are wonderful.
All right, let's jump right in, Rosemarie. So what does informal mean in terms of an informal family law trial?
Well, an informal family law trial is not as rigid or as scripted, you might say, as a formal trial. You get to speak directly to the judge and tell the judge what you would like the judge to do in your case. You don't have to ask questions of anyone else, and in fact, you can't. You get to speak directly to the judge. You have to select this method of trial and have to let the judge know you want an informal trial.
Okay, so I can talk directly to the judge. Is that true?
That's right. You can speak directly to the judge. And remember, during your trial, this is a court proceeding, and what the judge does is very important in your life. You want to dress appropriately. You can't chew gum or eat food. You cannot wear a hat unless it's for a religious reason. But when you speak to the judge, you're talking to the judge. Look at the judge, not at the other party. You're not going to be interrupted by the other person. The judge may interrupt you to ask questions that he or she needs to know, but you get to talk to the judge directly. It always helps to write notes before you're going to talk to the judge about what you want to cover. You can even have something that you're going to read from and tell the judge, this is my story, and these are the things that I'd like the judge to do. I always think when you're talking to the judge, it helps first to tell the judge, this is what I'm asking Your Honor to do. Child support of $500 a month, the children will be with me, whatever it is, and then explain why you want each of those things.
Okay. And what evidence does the judge consider in a family law trial, informal family law trial?
You can submit statements from witnesses, like friends who have seen you as a parent and observed you with your children. They have to be in a declaration format, which starts I, Mary Rodriguez, declare. And then Mary types in what she wants to tell the judge. And at the end, she signs it. I declare under penalty of perjury of the laws of the state of Washington that the foregoing is true and correct. Signed at whatever city, like Bellevue, Washington, on, and then the date. It needs to be typed. Now, the library has a declaration format and can help you with that. I believe a format is also available for free at the website for the courts, declaration form, to help you use that. If you have a house appraiser, you can ask the judge if the house appraiser can testify. But the beauty of an informal trial is that you can submit the report to the judge as evidence. You have to do it on time. And we're going to talk about your rules that you still have to follow, your time constraints, but you can submit it in that fashion. Sometimes there may be a guardian ad litem who's helped the court decide the parenting plan, or a CASA volunteer, that's court-appointed special advocate, that helps the court with parenting issues. And they may testify. If you want those people to testify, you definitely have to alert the clerk of the court, of the judge to whom you've been assigned, and the other side that you're going to be calling these people as witnesses. When you present your statement, though, the judge is going to ask you some questions. Be sure that you've looked at the state laws governing the issues in your case. The library has those, and they're also available online. It's a good idea to read those so you know, oh, these are the things the court has to consider. For example, parenting. Here are the statutes. Those are the state laws you want to look up either online by typing into the search engine the numbers I'm about to give you, or go to the library and the librarian will help you find these laws. In parenting, it's RCW, that stands for Revised Code of Washington, 26.09.181, 26.09.184, 26.09.187, and 26.09.191. In terms of child support, remember, not only do you have state laws, 26.09.100, 26.19.090, which is college support, 26.19.071, you also have the King County local family law rule 10. Now, the clerk's office at the courthouse has a wonderful link so that you can obtain a copy of the King County local court rules. The librarian can also help you find this. King County Local Family Law Rule 10 requires that you provide the court 2 years of tax returns, 6 months of pay stubs, 6 months of investment account records, 6 months of 401k and IRA records. And if you have any property, the court will want you to prepare a list of the property that you have. When you present these financial records, be sure that you redact, bank statements, redact, take out, erase, block off or black off the account number. For bank statements, you're going to leave the last 4 digits. Social Security numbers, I white out or black out the entire Social Security number. The court rule says you have to do all but the last 4 digits, but I've found that there are credit card companies and other companies that use that to access your account. For property division, RCW 26.09.080, and for maintenance, what we used to call alimony, read RCW 26.09.090. They're not long, but they're very important, and it's what the judge will want to look at when he or she makes a decision in your case.
Great. Thank you, Rosemary. It's extremely important, I understand, to pay attention to your case schedule.
Oh, yes. So when you filed for divorce, or when your spouse or partner, filed to end your relationship, filed for divorce, they were issued a case schedule. They were required to give a copy of that to you. And if you filed, you were required to give a copy to the other person. That's like your Bible. Those are your rules. You read that because that has deadlines by which you have to announce who your witnesses are, by when you have to, the opportunity to change the trial date and other deadlines. But there's another important rule that the court gives you, or order the court gives you, about a month and a half before your trial date. The judge will either issue to you and your spouse by email, usually, or maybe mail, an order, a pretrial conference order. Sometimes the court will have a telephone conference with the parties in which that's discussed, or require you to come into court to set forth the rules for trial. That pretrial order also contains many deadlines you have to follow. It's a long one. It's about 16 pages. So don't be intimidated by it. Start reading it and put those dates into your calendar, into your memory bank, because if you miss one, you can lose a golden opportunity. For example, if you have a parenting evaluation, you want to provide a copy of that. I'm looking at pretrial order I had in one of my cases. That was required 14 days before trial. If you have financial issues, you want the court to divide property or debts or award maintenance or child support, you have to prepare a financial declaration. That's a form available for free from the Washington State courts. It's your budget, and it tells the court a little bit about how much you have in property. That financial declaration, along with the documents required by local family law rule 10, that we talked about a few minutes ago, that has to also be prepared and delivered to the other side and to the court, filed with the clerk in time. And here, my deadline was 14 days before trial. Witness list had to be shared. Exhibit list had to be shared. And then 5 days before the trial, we had to tell the judge what evidence, what exhibits we were presenting. So you'll see in the pretrial conference order many deadlines. Follow those. When you submit a statement by a witness that you want the judge to read, you have to share a copy with the other side. When you prepare your own statement that you're going to read to the judge, when you testify to the judge, you don't have to share that with the other side. But now if you decide you want to write up what we call a trial brief, rarely is it brief. Usually it's 10 pages or longer. But if you write something for the judge and say, I want the judge to consider this law and how it affects my case, that you have to share with the other side. So be careful of those rules. There are some free clinics offered, a family law clinic by the King County Bar Association. Try to get into one of those if you need help understanding how do I present an exhibit? What do I do in terms of sharing it with the other side?
Okay, so in an informal family law trial, who gets to ask the questions?
Oh, that's the nice thing for you, because in an informal trial, you just talk to the judge and the other person does not get to interrupt you, does not get to ask any nosy questions. Only the judge gets to ask you questions. And likewise, cuts both ways. You can't interrupt the other side to say, well, I saw you out on Saturday night. No, only the judge gets to ask the other side questions.
Okay, great. And who can be a witness in an informal family law trial?
Well, you're not going to be calling many witnesses in an informal family law trial, because if you have a lot of witnesses and there are issues about what each witness is saying, someone will want the opportunity to cross-examine the witness. But in an informal trial, let's say you have a CASA person, that would be a person, a volunteer who's doing the parenting plan analysis, recommendations, and you might have a guardian ad litem that's going to testify. Those are witnesses. Sometimes if you've got a house that you've had appraised, you might want the real estate appraiser to talk to the judge. That would be a witness that you would identify. Those are some of the witnesses. Sometimes you might have a doctor you want to testify to talk about your debilitating illness. And those would be some witnesses you could call, but you wouldn't question the witness. So when you have a witness in an informal trial, you have to let them know this trial's a little different. It's informal. You'll be called by the court. You appear for the Zoom hearing. And when you walk in for the Zoom hearing, you will get to talk to the court. And you want to be sure to tell your witnesses, yourself, the rule. The court does not want, when we have Zoom proceedings, that you have a background, an artificial background. I'm sure there's a fancy word for it in technology. That really draws on the bandwidth of the court's computer system and has caused problems. You just want to be careful that your background is neutral. If you've got a parenting dispute, having large photos of your children is not a good idea. You don't want, sports team memorabilia behind you. You just want a neutral background.
Okay. And so you kind of sort of answered this question already, but I'll ask it one more time. So can I ask the witnesses questions in an informal family law trial?
No. That's why I should have elaborated. Prepare your witness to let them know, to tell the truth, to talk to the judge, to tell the judge what he or she thinks is important about his or her report. Have the report in on time. There's going to be a time for exhibits. That would be a report, such as a house appraisal. And be sure you've shared it with the other side on time. And that pretrial conference order is going to tell you that deadline by which you have to do that.
Great. Thank you very much, Rosemary. Hopefully this gives our listeners a better understanding of what an informal family law trial is all about and how it differs from a traditional family law trial. Thank you very much.
Thank you.
See you next time.
Thank you.